Hello students, and welcome back to Political Science 1513, American Federal Government. I am still your instructor, Connor Alford, if you can believe it. And in today's video, we're going to begin to talk about some of the particular civil liberties that are either protected in our Constitution or that have gained protection through the Supreme Court's interpretation of the Constitution, as would be the case for the penumbral right to privacy, which we'll talk about later on. For now, let's go ahead and get started with our learning objectives. The first learning objective today is going to ask you to discuss what the Constitution has to say about the freedom of religion and how the Supreme Court has interpreted this. In order to satisfy this learning objective, make sure that you're familiar with both the Free Exercise Clause and the Establishment Clause. The second learning objective asks for you to describe what the Supreme Court has had to say about the freedom of speech and when it can be limited. You need to know the differences between protected and unprotected speech. You need to know about the Miller test, and you need to know about the Brandenburg test. The third learning objective asks for you to detail what the Supreme Court has had to say about interpreting the Second Amendment and whether or not it applies to individuals. The next learning objective asks for you to explain how the right to privacy was created and where it comes from according to the Supreme Court of the United States. The final learning objective asks for you to identify the procedural rights that are described by our Constitution and explain how the courts have interpreted and attempted to protect these rights over time. In particular, we're going to be looking at the Fourth, the Fifth, the Sixth, and the Eighth Amendments. Let's go ahead and get started with the First Amendment, freedom of religion. So the First Amendment is very comprehensive. It does protect our freedom of religion. It protects our freedom of speech, but it also protects our freedoms of association, our freedom of the press, and our freedom of petition. In other words, it's very comprehensive, and that means that we don't have time to go through the entire First Amendment. So what I've decided to do is to focus on religion and speech, as these are some of the topics that students find the most interesting and helpful. But please don't infer from the fact that I am excluding the freedom of association or press, for example, to indicate that they're any less important. I'm not making a normative statement by choosing to talk about religion and speech. I am simply making a necessary sacrifice by excluding content that we just don't have enough time to talk about. So we are going to start by looking at the freedom of religion, because this is one of those fundamental rights that the framers thought was perhaps the most important. A number of states did actually introduce their own proposed amendments for the Bill of Rights, and one of the only two that was universal to every single proposed Bill of Rights was this freedom of religion. So let's talk a little bit about that. In the First Amendment, we're really going to find two clauses that deal with religion. The first clause that deals with religion is going to be what we call the Establishment Clause. And this one reads, Congress shall make no law respecting an establishment of religion. And then we've got the second of the two clauses, which is going to be the Free Exercise Clause. And that adds to the Establishment Clause a specific provision stating or prohibiting the free exercise thereof. So taken together, Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof. These are the Establishment Clause and the Free Exercise Clause, respectively. Now, the Establishment Clause, generally speaking, was originally understood to prohibit the federal government from establishing a national religion. If you traveled to England at this time, they had an official church, the Anglican Church. And we were basically making this statement with the Establishment Clause that we wouldn't do the same thing here in the United States. Do note, however, that many states had their own individual state-level religions, but that's a separate issue. The bottom line here is that it was originally expected to prohibit the establishment of a national church. But the interpretation of the Establishment Clause by our courts has been substantially larger. And to illustrate that point, we're going to talk about our first religion case. That's going to be Lemon versus Kurtzman. In the case of Lemon versus Kurtzman, we basically had a number of states, in particular Pennsylvania and Rhode Island, that wanted to use tax dollars to subsidize private schools. Now, the original stated intent that the state used to justify this policy was that they wanted to make private schools more accessible to indigent populations. In other words, by providing some tax funds to certain private schools, the state was able to lower the tuition costs that those schools charged, and when tuition costs go down, those schools become more accessible to people who have less money. Well, that's perhaps a noble goal, but there's a problem. What we're going to discover, in the case of Lemon versus Kurtzman, is that a majority of private schools are Christian schools in our country. Now, this probably isn't true in some other countries, but it's definitely true here, and it was certainly true at this time. So what that meant was that a number of Christian schools were basically getting tax money to help them reach new demographics of people in the general population. And a lot of people took issue with that. Now, keep in mind, the state thought that it was acceptable because nobody was officially endorsing Christianity, and nobody was being forced to attend these schools. The option was simply being made available to people of lower socioeconomic status. But some people did have problems with it. And the reason that people took issue with this is that some of that money was being used to basically pay teachers. And these private schools would hire teachers who did, indeed, teach a number of critically important secular topics, including language skills, mathematics, and science. But they also taught classes on the Bible, and they led students in prayer, and they provided spiritual instruction. All of this was done on the job. And so what we're going to discover here then is that there was a sense among certain people that this amounted to respecting an establishment of religion against the First Amendment's Establishment Clause. Because now what we have are people who are being paid at least in part by the state, and who, while on the job, are using their position to influence people and to spread their religious beliefs. And the Supreme Court is going to tell us in Lemon versus Kurtzman that that's not okay. So in Lemon versus Kurtzman, we learned that publicly financing these religiously driven and characterized private schools is thought to be a violation of the Establishment Clause. And to explain this, the Supreme Court is going to create a standard called the Lemon Test. Now remember from our prior lecture, the Supreme Court's job is to help us take the general principles of the Constitution and interpret them so that we can figure out how they apply to particular cases. And that's what the Supreme Court is trying to do with the Lemon Test. They're trying to give us a universal standard that we can use to determine when a law or government action has violated the Establishment Clause and when it has not. And the Lemon Test basically is a three-pronged judicial standard for making this determination. So what does the Lemon Test require? What does it say? Well, the Lemon Test tells us that in order to be consistent with the Establishment Clause, every government action that comes into question must satisfy three conditions. First, that government action must serve a legitimate, non-religious state purpose. Second, that government state action must not prohibit or advance a religious practice or belief. And finally, it must not create an excessive entanglement between church and state. So, in other words, when the Establishment Clause tells us not to respect an establishment of religion, the courts have interpreted this to prohibit not just the federal Congress, but all government actors from implementing laws which prohibit or advance a religious practice, which only serve a religious purpose, or which create an excessive entanglement between church and state. Now, the Lemon Test is very useful, but it has some limitations. It's got a couple problems. And the most notable problem with the Lemon Test is that it's really vague. In particular, that last prong, excessive entanglement, is very subjective. How much entanglement would we say is excessive? Where do we draw that line? So, for instance, what we're going to find is that some level of entanglement is inevitable, and we observe this every day. Most of you who attend a religious service each week probably get to your church, your mosque, or your synagogue by driving on public roads, which are financed, regulated, run, operated, and maintained by the government at the taxpayer's expense. So in a sense, the government is already helping people to get to their places of worship so that they can learn about religious doctrines. Is this not excessive entanglement? Well, no, probably not. The courts don't seem to think that building roads near churches is a problem. But funding churches or their schools, well, that's excessive, based on the Supreme Court's subjective determination. We've got a similar issue with this statement that the policy challenged on Establishment Clause grounds must serve a legitimate non-religious state purpose. Well, who gets to make the determination as to which of the state's purposes are legitimate? And who gets to decide whether they are religious or not? I'm not really sure. I suppose the answer to this question would be the court, but again, understand that the problem with the Lemon Test is that its various prongs are very subjective. So while the court has attempted to give us a universal standard that we can use in any Establishment Clause case, it hasn't really succeeded. It's come close, but at the end of the day, there are, again, some limitations associated with the Lemon Test. So the next religion clause is, of course, the Free Exercise Clause. If the Establishment Clause says that Congress shall not respect an establishment of religion, remember that the Free Exercise Clause tells us that it shall not prohibit that practice of religion. But does this mean that we have an absolute freedom of religion and we can practice whatever religion we want? Well, according to the Supreme Court, the answer to that question is no. The freedom of religion is considered fundamental, and by and large, we provide it with a great deal of protection in this country. But there are certain limits. I could not, for example, sacrifice virgins if I claimed that it was a part of my religion. There are certain sects of Islam that originate in certain parts of Africa and which have been exported into other parts of the world where people consider it their religious duty to mutilate the genitalia of their daughters. If you don't believe me, look up FGM, female genitalia mutilation. This is an international human rights issue, and it's one that we've had to deal with here in the United States. They're claiming that this is a part of their religious practice. Does that automatically authorize them to mutilate their daughter's genitalia? Well, no, clearly not. But again, what we're going to have to figure out is, where do we draw that line between protected free exercise of religion and something else? Well, to answer that question, we're going to look at another Supreme Court case, and that's going to be Oregon versus Smith. So in Oregon versus Smith, basically what we had were a couple of Native American gentlemen who, as a part of their tribal religion, ingested peyote during a legitimate religious service. This became a problem for these gentlemen because they happened to work at an Oregon-based drug rehabilitation facility. And because this was a drug rehabilitation facility, their employers took the sobriety of employees very seriously and wound up basically administering drug tests, and both of these gentlemen tested positive for peyote, at which point they were fired. Now, that doesn't sound like an especially controversial circumstance, but it becomes one very quickly, because Oregon and the federal government at this time and today both had and have laws dealing with what we call wrongful termination. Wrongful termination is basically when somebody is fired for wrongful reasons. Usually this is invoked when they've been fired on the basis of their religious practice, their race, their gender, or their disability. And basically, these two gentlemen claim to have been wrongfully terminated on the basis of their religious practices. And when an individual is wrongfully terminated, they are entitled to receive certain state benefits. More particularly, they are entitled to receive unemployment. So these two gentlemen, they sue to receive unemployment, and they are denied by the state of Oregon, which says that they were not fired in violation of their free exercise of religion. They were fired because they broke the law. So they appeal this decision by going to the courts and working their way all the way up to the United States Supreme Court in the case of Oregon versus Smith. By the time they get to the Supreme Court, they're no longer satisfied just trying to get their unemployment benefits. They want those. But now what they are asking the court to do is to strike the law prohibiting the use of peyote altogether as an unconstitutional violation of their free exercise of religion. Now again, I do want to be completely clear. This was a legitimate religious practice that members of their tribe had participated in for a very long time, before white folk ever showed up on the North American continent. So this is not just a case of two guys trying to get high. This is a case of two guys who are being impeded in their ability to practice their religious traditions because those traditions happen to incidentally conflict with existing state policies. And so the question here is whether or not the government is allowed to create laws which just so happen to conflict with our religion. Now, we know that they're not allowed to create laws that target our religion. If Congress were to create a law prohibiting a particular Jewish religious ceremony simply as a way of snuffing out Judaism, that would, of course, be unconstitutional. There's no question about that. That's settled law. But here, that's not what's happening. Instead, we have Congress creating a string of laws that are designed to basically prevent drugs from being proliferated in our streets, to help protect us from the deleterious effects of the drug culture, of the drug trade, and of the ingestion of hallucinogenic substances. And it just so happens that one of those particular substances is consumed by a group of people in their religious practices. So Congress didn't create prohibitions on peyote as a way to snuff out religious spiritual traditions. It just so happened that some traditions conflicted with that law. And so now the court's got to figure out whether that's a problem. And the answer here is no. In other words, what I want you to understand is that in Oregon versus Smith, the Supreme Court tells us that the Free Exercise Clause does not prohibit Congress from creating laws which incidentally conflict with religion. Okay, it does tell us that they are not allowed to target religion. But your free exercise of religion is not a get-out-of-jail-free card. It is not an excuse to engage in illegal conduct. So, for instance, we also have laws prohibiting polygamy, and those have been upheld by the courts, even though certain religious sects, including portions of Mormonism, are going to tell us that polygamy is God's will. And we're going to have issues with things like sending unvaccinated children to public schools. By and large, what we're going to discover is that the courts have told the states that they are allowed to require vaccination, even if it might just so happen to conflict with the religious practices of certain people. So, in other words, after Oregon versus Smith, we've clarified the boundary. Incidental conflicts between the state and individual free exercise of religion are resolved by asking ourselves whether the state's actions are targeted or not. And if they are targeted, they're probably unconstitutional. But if they're not, then as long as they serve a legitimate state purpose and they're rationally related to realizing that purpose, they're going to be upheld. Do note, however, that the court also continues a distinction that they'd already established in prior law when they issue the ruling in Oregon versus Smith. And this distinction draws a line between religious belief and religious behavior. The court basically tells us that your freedom to believe something is absolute, but your freedom to act on those beliefs, to engage in religious behaviors, is not absolute. So the government can create a law which just so happens to prohibit the use of peyote, but it cannot create a law which prohibits you from believing that the ingestion of peyote is an important part of coming closer with some higher power. So belief is untouchable, but incidental abridgment of free exercise or action, that's a totally different issue, and that's acceptable according to Oregon versus Smith. All right, let's go ahead and move on to the next freedom that is going to be protected in the First Amendment, and which we are going to discuss. And that, of course, is going to be the freedom of speech. Now, again, remember, there are other freedoms that we're not going to address, like the right of the people peaceably to assemble and to petition their government for a redress of grievances. That's also in the First Amendment, but we're going to conclude by looking at our free speech and how it's been handled by the Supreme Court. So we do know that there is a freedom of speech. The Constitution pretty clearly says so. But true to form, remember, the Constitution is really vague. We don't know the parameters of that speech. We don't know what forms of expression are covered by that protection of free speech and what forms are not covered. And we don't know how those can be limited. But generally speaking, here's what I want you to understand. The courts have decided that there are, broadly speaking, two categories of speech. There is constitutionally protected speech, and there is unprotected speech. And the forms of protected speech that the Constitution covers are going to be political expression and, to a lesser extent, some forms of commercial speech. Right, so you do have a First Amendment ability to advertise your business or to inform the public about the products, goods, and services you offer in order to make a living. But broadly speaking, the courts have told us that the core function and the most important protected speech is going to be political expression. But I also want you to understand that the courts have interpreted this concept of political expression, this idea of free speech articulated in the Constitution, very broadly. The United States, generally speaking, is thought to have some of the most expansive free speech laws of any nation anywhere in the world. We don't have, for example, laws which allow the government to determine certain forms of political expression constitute hate speech and therefore prohibit those forms of expression. The courts have pretty routinely rejected those kind of laws. So what we're going to discover then is that we do have very free speech, and this is especially true under the current Supreme Court. Under the Rehnquist-Roberts Court era that we're currently under, what we will learn is, again, that the courts are very amenable to individual claims that their free speech has been violated. They're very protective of political expression. But again, we have to ask ourselves, what counts as political expression? And are there limits on this? So, for instance, one thing we might have to ask is whether the freedom of speech is universal to all persons, or whether it can be limited based on identity. So, for instance, does a student in school have the same free speech as a private adult citizen out in the general public? Well, to answer that question, we look at a 1969 case called Tinker versus Des Moines. Now, I don't want you to focus too heavily on memorizing all of the details of the facts of the cases. I want you to focus primarily on their significance and their rulings. But to contextualize, in 1969, we're looking at the Vietnam War era, and this was a period of immense domestic unrest for our country. People were very dissatisfied. And among those who were unhappy about what our country was doing in Vietnam were a group of students who decided that they would attend school wearing anti-war armbands. Now, this became a problem for those students because it happened that their schools had very stringent dress codes. These were public schools, mind you, but at this time that was not uncommon. And these armbands were a violation of the dress codes. And not only were they a violation, but they were a violation which was offending certain people who supported the war or who thought it was unpatriotic to oppose it in public. So these students were basically asked to remove the armbands, and they refused to do so, at which point they wind up getting expelled. Their parents aren't happy about that, and they feel that this is a violation of the students' freedom of expression. And the school says, no, look, students don't have that freedom of expression that an adult citizen out in general public enjoys. If they did, it would be very disruptive. Furthermore, the schools are going to basically say, look, this isn't an issue of speech. They weren't speaking. They weren't verbally articulating any ideas. They were violating a dress code. So it's an issue of dress code, not of speech. And they say what you wear to school as a student is not protected by the First Amendment. Well, the Supreme Court's going to disagree with that argument. In the case of Tinker versus Des Moines, the Supreme Court tells us that being a student doesn't deprive you of your free speech protection under the Constitution. So students, they do have protected speech. At the same time, what we are going to learn is that the Supreme Court tells us that the freedom of speech is broad enough to encompass not just literal verbal articulation, but virtually any form of political expression to include symbolic expression. And they're going to tell us that one form of symbolic expression is wearing an anti-war armband or other pieces of political paraphernalia. So expressing yourself through what you wear is going to be protected, even if you're a student. Incidentally, this idea that the freedom of speech applies to people regardless of their particular identity, whether they're a student or not, is later on going to be expanded to protect a collective right to free speech. The courts will tell us in other cases that just as I have the freedom to say I support candidate X, so too do we as a group have the freedom to get together and say we support candidate X. Why am I bringing this up? Well, remember our discussion of Citizens United in prior cases. This case in Tinker versus Des Moines is going to set a precedent which will continue to expand until eventually we have protection for the speech of corporate entities. But that's not really our focus here, so don't worry about it too much. The next question we've got to ask ourselves is, well, if we're going to interpret the freedom of speech to encompass forms of symbolic expression, what kinds of limits can we attach to that? And to answer that question, we're going to look at Texas versus Johnson. In Texas versus Johnson, we've got a flag burning case. And again, we don't have time to get into the details, but basically there was a protester who ripped down a flag and he lit it on fire in Texas to express his opposition to how the Reagan administration was running our country. Now, this was meant to be a form of political expression. He could not think of any way to make the depth of his dissatisfaction with our government more clear. He understood that burning the flag would upset a lot of people, but that's why he did it. He recognized that it was a really, really potent message. It sent a very strong message about his feelings towards our country and our president. And he also recognized that this was a form of speech which would get a lot of people's attention. So it was an intentionally inflammatory action designed to convey the depth of his dissatisfaction. And that is a form of political expression. Expressing dissatisfaction with your government or even your country is political expression. But this particular form of expression is really offensive to many people. And so there were laws that prohibited it. And in Texas versus Johnson, our plaintiff is going to be arrested, and he's going to challenge his arrest on the grounds that arresting somebody for burning the American flag is a violation of the First Amendment. So that's the question that eventually makes it to the Supreme Court in Texas versus Johnson. Can Congress, can the government, or the states prohibit individuals from burning the flag on the grounds that this is such an important symbol? Or is flag burning a protected form of speech? And the court tells us that flag burning is a protected form of speech. They say, look, this is a really offensive form of speech, and that we think what this guy did is reprehensible. We would never do it. We don't think you should do it. And if you think less of him, fine. But they say the First Amendment's protection of speech is only ever going to be necessary when we're talking about controversial speech. If you're expressing yourself in a way that people find benign or agreeable, they're not going to be upset. It's only when you start to share views or express yourself in ways that they don't like that people will try to censor you or to silence you or to shut you up. And what we will discover then is that the only time we need the First Amendment protection of speech is when our speech is controversial. Well, flag burning is controversial. So this is the time at which the free speech clause in our Constitution can have meaning. If you're going out and you're wearing a shirt that says, please don't murder puppies, you don't need the First Amendment because no one's going to silence that. It's only, again, when you're trying to express yourself in a manner that others do not like, that isn't popular either with the government or the general public. So, in other words, political expression is a very broad category, and it's going to protect some forms of symbolic expression or speech that we might not like. But that doesn't mean that there are absolutely no limits on protected speech. What we will discover is that certain forms of speech can classify as unprotected. For example, we will discover from cases like Jacobellis versus Ohio and Miller versus California that the First Amendment does not protect obscenity exposed to the public. In the case of Jacobellis versus Ohio, we're basically dealing with a legitimate Hollywood film that was censored on the grounds that it happened to contain a very graphic sex scene. And the courts struck that censorship. They said you can't censor this because it's art and it contains real, meaningful expression. But they say if it were a pornography, then you could prohibit that. Okay, so let's be clear. The free speech clause in our Constitution has never been interpreted and was never intended to be interpreted as protecting your ability to peddle pornography. But how do we distinguish between a Hollywood movie, which just so happens to have a graphic sex scene, but is nevertheless a legitimate and a artistically valuable form of expression, and an actual pornography that's just obscene? Well, in Jacobellis versus Ohio, the answer we get is, I know it when I see it. If you show me a porn, I can identify it, but I'm not sure how to define pornography. I don't know how to define obscenity. So this case is not very satisfying to very many people, because remember, the court's job is to help us figure out how to apply the Constitution, and in this case they say, I know it when I see it. It's not very helpful. So a couple of years later, the same exact question comes up. How do we define obscenity? And this one's going to emerge in the case of Miller versus California. Now, in the instance of Miller versus California, we're not dealing with a controversial Hollywood film. We're dealing with a dude who's going around and he's putting pornography in people's mailboxes as a way to advertise his pornography operation. And he's arrested because you can't go around putting porn in people's mailboxes. It's not okay. And he sues on the grounds that that is a violation of his constitutional right to express himself and to share information with the public about the goods or services that he's providing. This gives us the case of Miller versus California. Now, it seems pretty clear to us that putting pornography in people's mailboxes is obscene. And the court recognizes that. They say, yes, this is obscene, and therefore it's not protected. So no, nobody's free speech has been violated. Okay? But the important thing to remember about Miller versus California is that it gives us the Miller test. And the Miller test is a judicial standard that we can use in order to decide whether a particular instance of speech or expression falls into this category of unprotected obscenity. And the Miller test is going to be a four-pronged judicial standard for making this determination. So the Miller test says that speech can be classified as obscene and therefore unprotected if, number one, the average person finds it in violation of community standards. Number two, it has a prurient or a prevailing interest in sex. Number three, it is patently offensive. And number four, it lacks literary, artistic, political, and scientific merit. So again, the Miller test says that speech is obscene if it is offensive or in violation of community standards based on the assessment of the average person. Okay, so number one, if the average person finds it in violation of community standards. Number two, if it has a prevailing interest in sex. Number three, if it is patently offensive in its content. And number four, if it lacks literary, artistic, political, or scientific merit. So yes, I'm sorry to tell you, but Twilight, Nickelback, they classify as pornography. That's obviously not true. They don't. But I bring this up because it, again, raises some questions. Like, who gets to make the determination of whether a particular product or instance of speech lacks artistic merit? That's 100% subject to interpretation. And I guess the answer, again, is the courts. The courts get to make that decision, but that's just not helpful. Because if you're trying to create rules regulating what types of things people can send to other people or put on the Disney Channel, it might be helpful to know in advance whether the courts will uphold that on the grounds that they agree with you in stating that this particular form of speech doesn't have artistic merit. So once again, the court is not doing a great job of helping us to figure out how to apply general principles to particular cases or controversies. But it is doing its best. The next category of unprotected speech is what we call incitement. You're not, generally speaking, allowed to incite people to imminent lawless action. But I want you to understand a couple of things about that. And in order to do so, you're going to need to look at the case of Brandenburg versus Ohio. So again, I don't want to get into the details here, but Brandenburg was a Grand Dragon in the KKK. And he basically delivered a speech to the public. And in this speech, Brandenburg was basically claiming that there was a secret cabal of minorities in general, African Americans and Jews in particular, that had secretly taken over the world and taken over the government of the United States and was using its control of the U.S. government to oppress the white man and to take this country from the white man. Now, again, this is obviously asinine. This is obviously crazy and offensive and irritating and stupid. But it gets worse because Brandenburg says, look, in light of this, at some point, the white man is going to have to wake up and start a racial revolution. And again, that's offensive. It's stupid, it's scary, and arguably dangerous. Because if people actually start grabbing their weapons and trying to start a race revolt, others are going to die. We in Oklahoma have seen this with the Tulsa race riots and with other race riots in our country. But what we're going to find is that the courts actually held that what Brandenburg did was protected speech. The case of Brandenburg is interesting because Brandenburg is arrested for inciting imminent lawless action. And up until this point, that had been the standard. The courts had used the imminent lawless action standard, which basically said that speech counted as incitement and was therefore not protected any time it was aimed at producing imminent lawless action. So if your speech was designed to get somebody or was encouraging somebody to do something which was illegal, which was dangerous to the general public, it could be prohibited. And these types of standards were used to do things like prevent you from shouting bomb on an airplane, or, to use a more period-appropriate example, shouting fire in a crowded movie theater. You're not allowed to do that because it would cause a panic and people would flee and somebody might get hurt. But in Brandenburg versus Ohio, they revised that standard. Because in Brandenburg versus Ohio, they're going to give us the Brandenburg test. And this is a two-pronged judicial standard used to determine if speech counts as unprotected incitement. And the Brandenburg test keeps the provision of the imminent lawless action test. So the first prong of the Brandenburg test says that speech might count as incitement if it is directed at inciting imminent lawless action. But it adds a second requisite. So the speech is incitement if it is directed at inciting imminent lawless action and it is likely to produce such action. So if you're trying to start a panic by shouting fire in a movie theater, that'll probably work. There's a pretty dang good chance that shouting fire in a movie theater will cause somebody to panic and do something that might otherwise be illegal, like slam their way through another person, causing physical bodily harm. But if I were to tell you to fire a nuclear weapon at China, there's absolutely no realistic possible chance that you are going to act on that. Because even if you want to, you can't. So it's not likely to produce imminent lawless action, and therefore it's benign. Still offensive, still obnoxious, but ultimately harmless and therefore protected. Well, the courts are going to tell us that what Brandenburg was doing falls into that category of offensive, stupid, and irritating, but it's not likely to actually produce any imminent action. Because here's the thing, if some crazy old kook came up to you and said, "Hey, grab your guns, we're seizing the Capitol," you would probably laugh at him. You're not likely to actually start a revolt just because some hateful old codger wants you to. So what we'll discover then is that the courts tell us in Brandenburg versus Ohio that speech counts as incitement only if it is first directed at inciting imminent lawless action, and second, likely to actually succeed in producing such action. The next category of unprotected speech is fighting words, and this exception is going to originate with a Supreme Court case called Chaplinsky versus New Hampshire. But you don't have to write that down, and it won't be on your test. The reason that I'm not going to include this on your test is that while technically this is still good law, those fighting words exemptions to First Amendment protected speech are on very shaky legs. Okay, so basically what the court tells us in Chaplinsky is that if you are instigating somebody to violence, if you are using words or language that is so offensive that you know when you say it to somebody, it will rouse enough anger to make them violent, that's unprotected. But let's think back to Texas versus Johnson. In Texas versus Johnson, we've got a guy burning a flag. That could incite some people to anger and violence. And not only does he do that, he calls people GD fascists. Again, these is very offensive actions on the behalf of Johnson, but his speech is protected because those fighting words exemption to protection for speech created by the Chaplinsky case is, again, technically good law, but the court itself has a tendency to ignore this exception. And there hasn't been a successful case argued on fighting words grounds in a very long time. Next, we've got defamation. And of course, there's going to be libel, which is written defamation, or slander, which is spoken defamation. And this is not protected speech. It's not necessarily criminal speech. Right? You can criticize people and you can spread mean rumors and you're not going to jail. But if those rumors cause damage or harm, like let's say somebody loses their job, well, they can sue you. And the court might force you to pay damages to that individual. The court here being a civil court rather than a criminal court, but nevertheless a court and therefore a part of the government. So it's not protected when you slander somebody. Although there are some exceptions for elected officials that we're going to get from a case called New York Times versus Sullivan. Conspiracy and solicitation, these are not protected speech. Okay, so this is how people are able to arrest you for trying to convince your friend to commit murder or trying to solicit somebody to engage in sexual intercourse for money or sell you drugs. Any words integral to the execution of a criminal act is considered outside of the scope of First Amendment free speech protections. Then finally, we've got child pornography. It's not okay, and it's not protected. Although there was a case called Ferber where the courts did hold that animated child pornography was totally fine. I do want to note just very briefly that child pornography is considered a separate category from obscenity. The argument here is that it's got to be treated a little bit different than just general pornography. Okay, so if obscenity and pornography are unprotected, child pornography is like extra unprotected. They're distinct categories. And that kind of brings me to a next point. So one thing I want you to understand about these free speech cases is that anytime a form of expression or communication is censored and somebody challenges that on free speech grounds and it goes to the court needs to first figure out whether this particular communication falls into a category that is protected speech or a category that is unprotected speech. The next thing they have to do is figure out whether it is all right for the government to censor that speech. There are some cases in which you can censor speech that would usually be protected. And there are some cases in which you can't censor speech that would otherwise be unprotected. And we don't need to know the details of that right now. I just want you to understand that this is not absolutely deterministic. Simply calling speech protected does not mean that it absolutely cannot be limited under any circumstances ever, according to the courts. And similarly, just because speech is unprotected doesn't mean that you can arbitrarily gag somebody. So that's the general precedent that you need to be familiar with when it comes to free speech. And having thus concluded our discussion of free speech, we move on to the Second Amendment in our Bill of Rights, which of course is going to be the right to keep and bear arms. Now this is one of the most infamous, this is one of the most famous or notorious, depending on your perspective, portions of the Constitution. It's certainly one of the most hotly debated. However, throughout most of our history, this hasn't been the case. And generally speaking, it was understood from the founding of our country, from the ratification of our Constitution and the Bill of Rights, all the way up until around the 1930s, that the Second Amendment prohibited the federal government from implementing pretty much any form of gun control. And so it's not until the 1930s that the federal government challenges this idea. And it's not until the 1930s, therefore, that we get federal gun control laws, which can be challenged in court. And what we will discover then is that there aren't that many cases dealing with the Second Amendment, and therefore, it's not going to take us a lot of time to talk about it. So, generally speaking, the Second Amendment reads, and I quote, "A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed." Now, that's a very choppy sentence, but this structure, or the way that this sentence is laid out, was very typical to the legal documents written at the time of our Constitution. And the courts are going to pay careful attention to that. So we're going to basically get two Supreme Court cases. And the first of these is going to be D.C. versus Heller. And in D.C. versus Heller, the District of Columbia, our federal district, basically created some very stringent gun control laws that banned basically owning firearms that fall into the category of handgun at all, and banned the ownership of any operational long-barreled firearm. Individuals in Washington, D.C. could still own a shotgun or a rifle, but they had to keep it disassembled, unloaded, clasped in a trigger lock, and securely stored. And there were no exceptions allowing them to remove the trigger lock or to take this firearm out in the case of, say, a home invasion. So these were some pretty radical limitations on the ability of an individual to keep and bear arms. And we basically had a security guard by the name of Heller, who was employed and trained to guard the United States Judicial Center. And he wanted to take a firearm home so that he could protect his family, because he was concerned about rising crime in his neighborhood and throughout Washington, D.C. in general. So he's told he's not allowed to keep a firearm, and he challenges that law. It goes all the way up to the United States Supreme Court. And the question here is whether or not this is a violation of the Second Amendment. Now, the city government in Washington, D.C. says that it's not a violation of the Second Amendment because the Second Amendment only applies to, and I quote, a well-regulated militia, according to their perspective. They point out that Heller was not a member of any militia, and he wanted to use the firearm for self-defense, not for any militia-related purposes. So the argument here has to do with whether your Second Amendment freedom to keep and bear arms is an individual liberty reserved to particular citizens like Heller, or it is a collective right reserved to militias. And in particular, what they're going to argue in D.C. versus Heller is that it is a right reserved specifically to the well-regulated armed forces run and operated by our government. So the National Guard, the Army, the Navy, so on and so forth. And if that's the case, then essentially what we're going to discover is that private citizens have no right to keep and bear arms, and states or cities or federal districts are allowed to prohibit those. But the Supreme Court says no. The Supreme Court says that there is no collective right to keep and bear arms. There is an individual liberty to do so. So we are still talking about negative rights here. And what we're going to discover in D.C. versus Heller is that the court takes a strictly textual approach combined with some in-depth historical analysis. In other words, if you read the opinion of D.C. versus Heller, which you can easily find online, you're going to discover that it breaks down like a grammar lesson. The courts look at the actual text of the Second Amendment, and they ask themselves, based on the laws of the English language today and at the time that this was written, what does this amendment literally say? And using the laws of the English language, they grammatically break it up into two distinct clauses. And these clauses are sometimes called the justification clause and the operative clause, or, if we wanted to use the exact language of the Supreme Court, the prefatory clause and the operative clause. For our purposes, let's stick to the language of justification clause and operative clause, simply because I think that the word justification in justification clause will help you to understand the purpose of this language. So the justification clause is that opening salvo. It is a well-regulated militia being necessary to the security of a free state. All of that language taken together constitutes what we call the justification clause. The remainder of this amendment, the right of the people to keep and bear arms shall not be infringed, is what we refer to as the operative clause. The operative clause grammatically tells us what right is being secured and who holds that right. In this case, it's the people. And the justification clause explains why they hold that right, why that right must be respected, because it is necessary to the security of a free state.
So in other words, you could rewrite this entire amendment and preserve the literal meaning if you wrote, "The right of the people to keep and bear arms shall not be infringed, comma, because a well-regulated militia is necessary to the security of a free state." So basically then, grammatically speaking, a literal reading of the Second Amendment clearly stipulates that there is an individual freedom to keep and bear arms. And this becomes even more clear when you recognize that, again, that right to keep and bear arms was present before the Constitutional Convention. It was a long-maintained tradition in English common law. And what we're going to discover is that a part of what led to the American Revolution was that this right to keep and bear arms for the purposes of self-defense and defense of the state was being violated by the British Empire, which wanted to disarm citizens out of fear that they would rebel. In fact, the Battle of Lexington and Concord, which started the American Revolution, initiated because the British sent troops to disarm Americans. And so what we're going to find is that, again, there's this long tradition of a right to keep and bear arms that existed in our country even before it was, in fact, a country. But there's more language in the First Amendment itself that we can look at. The right of the people is heavily discussed by the court in its opinion in D.C. versus Heller. And in this particular case, what they're going to point out is that, look, this language, the right of the people, appears elsewhere in the Constitution. It appears in the First Amendment, and it appears in the Fourth Amendment when it protects us from searches and seizures. So the First Amendment, for instance, says the right of the people peaceably to assemble and to petition their government for redress of grievances. And what we're going to discover is that we've interpreted that right to peaceably assemble as an individual liberty. You as a private citizen have the individual freedom to peaceably assemble with other like-minded people. Similarly, the Fourth Amendment gives us this language: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So here what we're going to discover is that we're finding an individual freedom from warrantless searches and seizures that begins with the phrase, the right of the people. So every other time this phrase, the right of the people, appears in the Constitution, it seems to designate an individual liberty. And yet in this case, the city of D.C. is asking us to interpret it distinctly, to say that in this one instance, it doesn't create an individual liberty. It creates a collective liberty. This is the only collective right in the entire Constitution. Every other liberty is an individual liberty except for this one. But the courts reject that. And again, they're going to do so on textual grounds. They take a very literal interpretation. But the Second Amendment is outdated. It was written at a time when firearms meant muskets, and today we have machine guns. And the court acknowledges that. They say, yeah, firearm technology has changed. It's much more destructive today. But the court dismisses this argument. It says, look, it's not our job to decide when the Constitution becomes obsolete or not. If you think that a provision in the Constitution has become obsolete, amend it. There's a legal means to do so. But we cannot simply declare the Constitution obsolete when we no longer want to follow it or now feel that it doesn't apply to our circumstances. So that's D.C. versus Heller. What about McDonald's versus Chicago? Well, very similar case, except we're looking at Chicago. And here's what I want you to understand about McDonald's versus Chicago. This is the case that applies the Second Amendment against the states and local governments. D.C. versus Heller says that the Second Amendment protects an individual freedom to keep and bear arms against the federal government. McDonald's versus Chicago tells us that it also protects that freedom from states and local governments because it's fundamental and indispensable to American tradition. The next right that we're going to talk about, negative right, mind you, but right, that we're going to talk about is the right to privacy. And this one's a bit different because all of the freedoms that we've discussed so far are explicitly protected in the Constitution. But if you found an electronic copy of the Constitution and you used a search function for the word privacy, you would quickly discover that it's not there. The Constitution never once mentions the word privacy. So where does our negative rights to privacy, our freedom to be private from public intrusion, begin? Where does it originate? How is it created? Well, in this instance, we're going to see that it was created by the Supreme Court in a string of rulings which begin with Griswold versus Connecticut. In Griswold versus Connecticut, we basically had a regional director for Planned Parenthood, Eliza Griswold, who was arrested for intentionally violating a law that prohibited contraception by selling it to a married couple. And in this case, the courts are going to review that law and ask whether it's constitutional. And they say no. And they justify this decision by claiming that a law prohibiting the use, mind you, the use, not the sell or the purchase, but the use of contraception violated a previously unheard of constitutional right to privacy. And they're going to justify this decision by claiming that the right to privacy, while never explicitly mentioned in the Constitution, can be inferred from those rights that are mentioned. So they are going to call this a penumbral right. And a penumbral right is basically an unnecessarily complicated way to say an inferred rather than an enumerated right. And in order to justify this, they're going to look at a number of different amendments. For example, they look at the 9th Amendment, which says that the enumeration of certain specific rights in this Constitution should not be interpreted or construed to deny or disparage other rights retained by the people. And so what the 9th Amendment tells us then is that there are certain freedoms that the framers might have forgotten to include in their list when they drafted the Bill of Rights. However, how do we go from this idea that there are unlisted freedoms to this notion that one of those freedoms is a right to privacy? Well, in answering that question, we have to do a fairly in-depth discussion, and we don't actually have time for that. I want you to understand that the court cannot agree on where the right to privacy comes from in our Constitution. In Griswold versus Connecticut, the plurality opinion, the court's opinion, relied on the 1st, the 3rd, the 4th, the 5th, and the 9th Amendments. In later cases, like Roe versus Wade, which expanded the right to privacy to encompass not just the use of contraception, but abortion during the first trimester, said that the right to privacy could be found instead in the Due Process Clause of the 14th Amendment. They said that if people are entitled to due process, then they are entitled to a certain degree of privacy. Now, it's very difficult to explain this logic in either case. But if we look at Griswold, we can focus on, say, the 4th Amendment, which again protects us from warrantless searches and seizures. And the court argues that this implies a certain right to privacy. Now, there are dissenting opinions where justices and attorneys say, no, it doesn't. But the court says, look, if we have this provision telling us that the government cannot search our private effects, that implies a right to privacy. Because if there isn't a right to privacy, why shouldn't they be allowed to search our personal effects? So that's, again, kind of the logic that they're using in this case to create a previously unheard of right to privacy. There's essentially no mention of privacy in any Supreme Court case prior to 1969. So why does it happen here? Well, if we're honest, and this is acknowledged by the justices themselves, this is a case of judicial activism. The judges on the court thought that that particular law prohibiting the use of contraception was silly and damaging to our country, and they wanted to strike it. So they interpreted the Constitution in a manner that allowed them to do so. And the same thing is going to happen in Roe versus Wade. The justices are going to be personally opposed to prohibitions on abortion, and they're going to see these as damaging. So they will find a way to interpret the Constitution which will allow them to strike those rules. That doesn't mean that they made the wrong decision. They might have made the right decision. It could be that the interpretation that they came up with to justify their decision is also totally valid. But I do want you to understand these are both generally accepted by the legal community and by scholars as activist cases. And they are also going to be very important because the next privacy case we're going to talk about is all the way in 2003. And this is the case of Lawrence versus Texas. Now, again, I'm not going to quiz you or test you on the facts of the case. But in Lawrence versus Texas, we have a gentleman who is homosexual. And he has a boyfriend who discovers that he's cheating on him and therefore decides that he wants to get revenge. So to get revenge, he calls in basically a false claim, an anonymous tip telling police that Lawrence is in a separate area selling drugs. And the police break into his home and they catch Lawrence having sex with another man, which at this time is in violation to a Texas law prohibiting sodomy or anal sex. And Lawrence is arrested for violating that law, but he challenges it, claiming that that violates his right to privacy, and he wins in the case of Lawrence versus Texas. So if Griswold versus Connecticut creates a right to privacy and interprets that right as broad enough to protect our use of contraception in the marital bedchamber, then Roe versus Wade expands that to encompass abortion, and Lawrence versus Texas further expands it to encompass consensual relations between adults in a private setting. But that private setting qualification is really important. This would have been a very different story if Lawrence and his paramour had decided to have sex on a public beach or on a public train or in the middle of the street or in somebody else's place of business. Because what we're going to discover is that what a person knowingly exposes to the public is not protected by constitutional rights to privacy or the Fourth Amendment's protection from searches and seizures. And we're going to learn that from the case of Katz versus United States, which helps us to bridge a gap between this right to privacy and the Fourth Amendment protection from warrantless searches and seizures. In Katz versus the United States, the Supreme Court tells us that we are protected from warrantless searches and seizures of our persons or effects only where we would reasonably expect privacy. Now, it's important to understand that this is not limited to your home. For example, if you went into a public restroom and you sat on the stall to poop and you closed the door, you reasonably expect privacy. And it would be a violation of your privacy for someone to try to lean over the stall and take pictures of you or to monitor what you're doing in there. That's not okay. If you used one of those old-timey phone booths, which is what happened in Katz versus United States, the moment you close that door to shield yourself from the public, you have a reasonable expectation that nobody's eavesdropping. So if the cops want to search your verbal correspondences by tapping that phone, they need a warrant. But if you're on a cell phone and you're walking down the street and you're loudly discussing your plans to do something illegal and a police officer happens to hear it, well, that police officer can arrest you. It doesn't count as a warrantless search for him to eavesdrop. Or if you assault somebody in the street and then you run and hide in your house, that officer doesn't have to go to a judge and get a warrant before he can break into your home and search it to find where you're hiding. So again, Katz versus United States tells us that where a person exposes something to the public, Fourth Amendment protections no longer apply. But where a person has a reasonable expectation of privacy, those protections do apply. So let's go ahead and take a moment to talk about the Fourth Amendment. The Fourth Amendment is the first of four amendments which are sometimes referred to as the procedural amendments, and these are the amendments which protect our procedural rights in a court of criminal law. They're going to be the Fourth, the Fifth, the Sixth, and the Eighth Amendments. All of these amendments deal with criminal procedures. They create rules about how we should carry out criminal prosecutions, all the way from the very beginning of gathering evidence of a crime and making an arrest, to bringing charges and convicting the accused, to punishing those found guilty in our state penitentiaries, and so on and so forth. But in particular, the Fourth Amendment protects our private effects from unreasonable searches and seizures. And generally speaking, the courts have told us that a search is unreasonable if it is conducted without a warrant in most, though not all, cases. There are some exceptions. Students who are living on campus, or athletes who are using a locker room, or when there are exigent circumstances, like, for example, if an officer believes that there's a bomb about to go off, then the courts have said, okay, go ahead and conduct the search. You don't have to go through a court to get a warrant. And there are also some other exceptions. An officer can conduct a search without a warrant, provided reasonable suspicion. Reasonable suspicion is an actual legal standard. It's not just a term, and it has a very, very particular meaning that's been interpreted by the courts through a string of cases. And basically speaking, a reasonable suspicion is a carefully considered presupposition based on specific facts and circumstances that a person is probably involved in a particular criminal activity. And before an officer can act on this level of suspicion, he needs to have, or she needs to have, specific knowledge to lead any reasonable, cautious person to conclude that a particular crime has been or is about to be committed by the suspect that they want to search. Okay, so again, a reasonable suspicion is a carefully considered presumption based on specific facts and circumstances. It's not enough to rely on your gut. That a person is probably involved in a criminal activity. Now, I do want to note that this involves sensory perception. So if you're driving along and swerving and you get pulled over and the officer can smell alcohol on your breath, that does authorize them to administer a sobriety test or even to search your blood by giving you a breathalyzer. And that's a form of search. They're searching your body for evidence of intoxication. But what we will also discover is that when there is no reasonable suspicion, which is usually the case, they will need to get a warrant. A warrant is advance written permission from a judge, recognizing that the police have reasonable grounds to suspect a crime has been committed or will be committed, and authorizing them to search a particular place or person for evidence of a specific crime. So do keep in mind it needs to be a particular place or person. If a warrant authorizes the police to search your home and they go and search your place of business, they've probably violated your rights, and you've got a pretty good grounds to challenge their actions in a court of law on the Fourth Amendment. But the Fourth Amendment also creates some rules about when judges are allowed to give a warrant to officers. They are not allowed to give it without probable cause. And again, this is a particular judicial standard. Probable cause is a reasonable ground to suspect that a person has committed a particular crime or that a specific place contains particular items connected with a specific crime. Now, under the Fourth Amendment, probable cause, which is more than a bare suspicion but not quite legal proof, has to be shown before an arrest warrant or search warrant may be issued. So these are procedural rules and regulations applied to the officers who want to gather the evidence and to the judge who would like to give them permission to do so. The judge may not issue permission without probable cause, and the officers can't act without permission. So this is, again, a set of procedures that the officers have to go through when processing a criminal act or a suspected criminal act. But here's a question that you might consider. How do we enforce the Fourth Amendment protection from warrantless searches and seizures? What if an officer is willing to take on any punishment as long as they can take somebody down? They've got a huge vendetta against somebody, or they really suspect somebody of having committed a crime which is so heinous that they would be willing to go to jail in order to bring that person with them. Well, it's not enough just to punish the officer, because they're, again, willing to take on any punishment. So how do we enforce the Fourth Amendment and also protect individuals from violations of their Fourth Amendment rights when an officer is dedicated enough to violating those rights that he or she is willing to break the law and face the consequences? Well, the answer to that originates with a case called Knapp versus Ohio. This is a 1961 case, and at this time it was illegal to own pornography. But what we're going to have is an African-American woman who does own pornography, and she keeps it in a little chest under her bed. And there is a call indicating to the police officers that she might be harboring a fugitive from the law, which is a crime. So they get a warrant authorizing them to search her home for evidence that this fugitive is in the house. And they arrive, they search her house, they discover that he's not there, that the tip was false, and that there is no evidence that this person had ever passed through. But they're angry, and they want to take this lady down, so they keep searching, and they keep searching until finally they find her pornography. They find some excuse to charge her with a crime. And so she's arrested for owning these obscene materials. And she challenges on the grounds that her rights were violated. Now, the officers say, look, we had a warrant, but remember what I told you. The warrant is specific. It authorizes them to look for evidence of a particular crime in a specific place. And while it was reasonable to think that she might be hiding a fugitive somewhere in her room or in a closet, you probably couldn't fit this guy into a small chest under your bed unless he's a contortionist. There's no reason to think he's a contortionist, so this is obviously unreasonable. They were searching for evidence of a crime other than the one that their warrant explicitly authorized them to look for. So this goes to the Supreme Court, and the Supreme Court agrees that her, MAP's, constitutional protection from unreasonable searches and seizures had been violated. And here's the interesting thing about this. They are then going to say that the police have to give her a new trial, and that this time they cannot use the pornography in the court as evidence. So that pornography is excluded from the court record. And it's going to be very hard for them to get her convicted of illegally owning pornography if they're not allowed to use the pornography they found as evidence. So MAP versus Ohio is important because it creates what we call the exclusionary rule. The exclusionary rule is a judicial standard stipulating that illegally gathered evidence is not admissible in a court of law. And this is a tool that we use to enforce our procedural rights. If an officer conducts an illegal search and finds evidence of a crime, he doesn't get to take you down because that evidence is not admissible in a court of law since it was illegally gathered. It must be excluded from the court record. Therefore, if the officer really wants to take you down, he's going to have to go by the books. He's going to have to respect your Fourth Amendment rights. Bottom line then, MAP versus Ohio creates the exclusionary rule to enforce the Fourth Amendment's protection from warrantless searches and seizures. However, what we're going to discover is that this exclusionary rule will subsequently be expanded by Miranda versus Arizona to encompass our Fifth Amendment freedom from self-incrimination. To incriminate yourself means to give evidence against yourself, which will be used to convict you of a crime in a court of law. Now, if you volunteer incriminating information, that doesn't mean that your Fifth Amendment right has been violated. But you can't be tricked or coerced into doing so by the police. And what the courts are going to tell us in Miranda versus Arizona is that in order to avoid inadvertently tricking you into thinking that you have to answer their questions, even if that's incriminating, the officers need to inform you of your rights. They have to Mirandize you. And you've probably heard that language. You have a right to remain silent. Anything you say can and will be used against you in a court of law. So again, what the courts are going to tell us, Miranda versus Arizona, is that when you are arrested, the police are required as a procedural obligation to read you your rights so that you know that you are free to remain silent. And if they fail to do so, and you subsequently give information to them that helps them prove you've committed a crime, they're not allowed to use that information against you in a court of law. So Miranda versus Arizona requires that you read suspects their rights and applies the exclusionary rule to the Fifth Amendment right to remain silent. By the way, that right to remain silent is the same thing as your freedom from self-incrimination. Finally, in 1963, what we're going to find is that Gideon versus Wainwright is going to apply the exclusionary rule to evidence gathered in violation of your Sixth Amendment right to an attorney. If you are interrogated and not given an opportunity to have an attorney, then the information that you yield or surrender to the interrogators cannot be used against you in a court of law. Now, if you voluntarily choose not to have an attorney, that's a different story. But that Sixth Amendment right to an attorney is also protected by the exclusionary rule. And that more or less summarizes our lecture today. I'll just conclude by looking briefly at the Eighth Amendment. It says no cruel and unusual punishment. Does this prohibit the death penalty? Supreme Court says no in most cases, but yes in some cases. For example, it has overturned as cruel and unusual laws authorizing states to execute people under the age of 18, or laws allowing states to execute those who are, to use the court's language, mentally retarded. So generally, yes, the Eighth Amendment allows for capital punishment, but it definitely doesn't allow for torture. And those are our procedural rights. So now that we've talked about our civil liberties, we're going to conclude next week by looking at our civil rights, and then we're basically done for the semester.